What are the trustee duties during a trust sale of a California property? That's our topic today. We'll get started right after this. The trustee acts as a legal owner of the trust assets and is responsible for handling any of the assets held in a trust, tax filings for a trust, and distributing the assets according to the terms of the trust. Both roles involve duties that are legally required. Welcome back to my channel. I'm KimWard. I am a certified probate real estate advisor, and my team and I, what we do here in San Diego, we help the trustee, executor, and administrators with the home of their loved one after your loved one passes away. And we have been doing this for almost 2 decades. The trustee, of course, has the right to sell trust property in accordance with the trust agreement created by the grantor. That's the person who opens the trust, also known as the trustor or settlor. When a trust is set up, the trustee duties or instructions are put into place as to what the trustee can do with the trust property, which might include money, stocks, bonds, real estate, or property in California, causing a trustee sale of the California property. And there may be other high-value assets. The trustee, which is a fiduciary duty of the trust, typically doesn't need permission from the beneficiaries to sell the trust property, but obtaining approval or giving beneficiaries an informal accounting can help the process run more smoothly. Experience shows when a trustee keeps the beneficiaries informed on a weekly or so basis, especially when considering the trust sale of the property in California, then the beneficiaries remain comfortable, ultimately helping the trustee with their trustee duties because they don't have to have long conversations with an upset beneficiary. Regarding assets transferred into a trust, they can be passed on to the beneficiaries outside the California probate process, which makes using a trust an advantageous part of an estate plan, saving a lot of time and a lot of money for the estate. So let's talk about, can a trustee sell trust property in California? It's the trustee's fiduciary duty to fulfill the terms set by the grantor, in many cases which may include distributing, investing, trust property in California. One of the trustee duties is to sell the trust property when specified in the trust document, whether or not the trust is a living trust or a revocable trust. When the decedent drafted a revocable living trust, they likely served as trustees, so they would be having the flexibility to sell the trust assets at their discretion. After the death of the trustee, a successor trustee will manage the assets and distribute them to the beneficiaries or heirs according to the decedent's wishes. If there is real estate, such as a property in California, the successor trustee may need to sell the California property so that the proceeds can be divided among all of the beneficiaries. Since the trustee duties includes selling a California property, can the trustee sell without the beneficiary's approval? In most cases, the trustee does not need final sign-off from the beneficiaries to sell the trust property. However, the trustee may want to get a written release from the beneficiaries anyway to prevent arguments down the line, since a beneficiary has the right to petition the court to remove the trustee. For example, if the trustee sells the California trust property owned by the trust, a beneficiary may argue that it was sold for less than the fair market value. Sometimes the trustee may also be a beneficiary. For example, you may be the trustee and beneficiary of a family trust created by your father. If your siblings are also trust beneficiaries, then you may want to consider getting sign-off from them before selling trust property to prevent any potential squabbling. You might contact your estate attorney to draft a notice of proposed action to be mailed to each of the beneficiaries. That way, when they sign consent to the proposed action of selling the trust property, you, as the trustee of a California property, will be fully protected. Another frequently asked question when considering a trust property in California is, can a trustee sell trust property to himself or herself? Trustees aren't allowed to sell trust property to themselves unless the trust agreement has explicitly allowed them to do so. They also shouldn't sell the trust property to another trust that they manage or borrow trust funds for personal use. Of course, if you are considering transferring the title to the trust property to yourself as the trustee, you'll definitely want to obtain legal guidance. Thanks for watching. I hope you found this of value. If you did, go ahead and comment down below, hit that like button, and I'll see you next week.